All right, call to order this meeting of the bipartisan bicameral working group on medical marijuana. Just kind of by way of introducing the process that we're going to go through today, which is an odd process, and in all honesty, we're somewhat making this up as we go here. So it should be an adventure. I tried very hard to get my co-chair to take the gavel for this meeting, but I lost the game of rock, paper, scissors. So when we started, we said that this process would be one where we spend a lot of time gathering facts, and we have spent quite a few weeks now gathering facts, trying to get the information that we needed to start making good decisions. And we are almost finished with that process. We have one other area in my mind that we have not covered. It will be covered next week, I believe, and that is the banking and tax issues that are caused by this, especially the banking problems that other states have seen. So we'll spend a little bit of time next week learning about that, but we wanted this week to move out of the gathering data phase and into the actually producing results, trying to do everything that we can to implement good rules and implement this in a way that is true to the state question, true to the will of the voters, and so that's our goal here. It is not going to be pretty. Just to kind of, I think the easiest way to explain what we're here to do today, on a normal bill, and in fact I did this yesterday, David sitting to my right here, he is for the Senate. He's on the healthcare staff. Any healthcare related bill that you see, odds are that David has written it with some input from other members of the staff on the legal side. But I have some bills that I'm working on for next session. So I sat down with David yesterday. I said, hey, David, here's 4 or 5 different bill ideas, different things that I think we probably need to address next year. And I gave him a very, very rough outline of what that needs to look like. And then he sits down, he drafts up that language, I look at it, we go back and forth trying to perfect it. Usually the next step in that process is that we take those bills that are not in the public domain. No one other than David and I have ever seen them. No one even knows that I'm working on these ideas yet. And I'll start showing those to other people that work in that area. So these are healthcare bills, so I'd be taking them, to the chair of the Senate Health, other members of the Senate Health Committee, trying to get those bills, perfected, try to make sure that they look good, make sure my ideas are not the craziest ideas ever. And so that's kind of the process, and all of that happens behind the scenes. All of that happens long before February, long before session starts. And so magically in January, all of these bills just begin to appear as if they just, came out of nowhere. But the reality is a lot of work goes on behind the scenes and even coming up with the idea and drafting those bills. So what we're doing today is somewhat unheard of. And it would have been a whole lot easier for my co-chair and I to have followed that normal process, for us to have sat down over the last couple of weeks and said, hey, we want to produce some rules for testing. Here's what we want the rules to look like. Here's what we want the rules to include. We could have taken that to David, said, hey, David, here's what we want, write it up. And we could have shown up today with bill language, with that draft that we could pass out to the committee. But that's not the process that we started with. We promised when this committee was created that it would be a very open and very transparent process. To be open and to be transparent, I expect that we're going to sit through an ugly meeting today because this is not normal. We don't quite know how to do this. But the goal of what we're going to do today is we've had 2 full weeks in this committee of testimony about what testing standards should look like. And so the question in front of us today is as we move forward in hopefully proposing some rules to the State Department of Health for them to adopt, what do we want in there? We have two basic models. We have the model that the State Department of Health gave us because they passed these rules originally. They retracted them later. And so those rules, which obviously they had done their homework and they seemed to be the rules that the Department of Health thought were appropriate. So we have those as a model. We also have the testing regulations from the Unity Bill. And so we have the Department of Health and we have the industry who have both weighed in. If you look at those, the things they have in common are immense, but there are some differences. And so today, what we'll do in a very open process is hold a committee discussion that is usually in this building held behind closed doors. But we're going to hold that discussion open for the public. And our goal today is to walk out so that David knows what the committee wants to see inside these rules and what the committee does not want to see inside of these rules. So to do that, I'm just going to throw out some subjects. After I'm done with my list of subjects, you guys will probably have subjects that you want to throw out. I'm throwing them out because somebody's got to try to corral this circus, and that's my job today. And then I want to discuss those subjects. I very much intend to do everything I can to keep us on task today. I think the reason we don't do bill drafting this way is because it's really easy to jump into putting on a show, jump into playing politics instead of playing statesmanship. And so I will do everything that I can to try to keep us on the subject at hand today. So with that, that's kind of an outline of what we're going to attempt to accomplish. I have no idea if this will be a 20-minute meeting or a 4-hour meeting. This is going to be an adventure, and it's really something I don't think that the state capitol, I'm quite sure the state capitol hadn't seen this in at least 15 years, so maybe ever, who knows. So with that, my co-chair have anything you want to add before we jump in?
No, sir. Nope.
All right, ready or not, here we come. The first thing that I have on my list of things that I want us to give the bill writer or the, I guess let me back up. Our goal here is to create rules and not to create a bill. And that's something that we need to be a little bit clear on. It's something that I actually had to try to get a little clarity on myself, because there are things that we can do statutorily that cannot be done through the rulemaking process. And so we need to be a little bit mindful of that. We also need to be mindful that bill language looks very different than rule language. And so some of the things that we're used to seeing is really not the way that this process is going to work, because our end result, our end goal here is to create a set of rules that we will send to the Department of Health and ask them to adopt those rules. And we do that, just as a reminder, because the Department of Health testified before our committee that they believe they do have the authority to implement those rules. And I intended to actually have that testimony in front of us in case someone has questions about that. I think my assistant may have those, and so I can get that if we want to review that testimony. But it's a pretty clear testimony from the attorney from the State Department of Health that they did not remove those rules because the letter from the Attorney General said they must. They removed those rules out of a very high level of caution after the Attorney General wrote his letter. But they testified that they believe that they can go in and re-implement rules. And so our goal is to give them a set of rules that we think they should move forward in implementing. And so with that, it's going to be one of the issues that we fight through here, is that the two things that we're working off of, one of them is a set of rules, and one of them is drafted statutory language. And so they're going to look different, they're going to be shaped different, and some of that's going to be unavoidable. In the end, that is why I believe that our staff members who know a whole lot more about this than I do will take what we suggest today and change those state health department rules to fit what it is that we're asking them to do, instead of taking the Unity bill and making those changes to it, because one is a set of rules and one is a set of legislation. If we end up getting to a point where we're working off of legislation, then I would expect us to pick up that Unity language and start working off of it. But since today we're working on rules, we will, the final product will be an augmented form of what the State Department of Health has already passed. So with that, the first subject that I want to throw out, and it's one that, and I'm Dr. I'm going to mess it up. I say his name wrong every time. Pasternak. Okay, in Southeast Oklahoma, it's Pasternak, but it's actually Pasternak. Is that convinced me in testimony a few weeks ago that if we are going to have a medical marijuana program, we must test for terpene levels. That is something that is in the Unity bill. It is something that the industry has asked for. It is not something that the Department of Health originally was going to test for, and so I want to throw that out. It is my personal wish that we add that. I think that that's something that helps this be a more effective medicine from everything that I've learned. And so I want to throw that to the committee of, is that a change that we're in favor of, or do we have more thoughts on how to go about that? So Senator Daniels has her hand
Thank
up.
you, Mr. Chairman. I have a question. I'm working off working draft version 1.5, July 7. Am I working off the correct one from the Department of Health?
That is the draft I have.
That's the one I'm going to mark up. Okay.
Okay, that's the one I have in front of me, so sure. David, is that, yeah, that's the one David's also working off of, which is probably the most important part of that. So questions, comments, thoughts on terpene testing?
Never mind.
Representative Loring.
I understand what you're saying there and agree with it, but shouldn't it be both terpene testing and labeling?
And yes, I absolutely believe so. And I think I would assume that everyone would agree that whatever testing standards we end up with need to correlate into labeling standards, and that'll be with the Board of Health. They've kept labeling standards in, and so we would just need to augment some of those labeling standards too. But yeah, in my mind, absolutely. The whole point of terpenes, from my understanding, is people needing to know this strain of marijuana, what effects it might have, and the terpene levels answer that question in a lot of ways. So thank you very much. I think that this needs to flow to labeling for sure. Senator Daniels.
I hate to put you on the spot, Mr. Chairman, but do we know in other states with medical marijuana programs how common it is to test for terpenes? I'm not opposed to it. I'm just curious to know. You may not be able to answer that.
David says he doesn't think it's very common.
Okay. Because that might, as we get into this, affect little, are we an outlier doing it? Is it something readily done? How complicated does it make things? Because I think it's probably a very good idea. I just wanted that background.
I know that it is done in other states. I do not know how many. I've seen labels from other states that contained this type of information. I do think that one of the things that we need to consider is I mean, there needs to be a threshold established here of, I mean, what percentage, you know, how much of a certain terpene needs to be in it for it to make it onto the label. Otherwise, you end up with labels that are pretty unwieldy. So that there's some science there. Senator Yak.
Thank you, Mr. Chairman. Do we know if there's a reason the health department didn't include terpenes in their rules? Is it just an oversight or something that they didn't think was important at the time? We don't know.
I don't know the answer to that question. Thoughts on terpenes, anyone? Okay, I'll ask it this way. See, this is why I said this would be an ugly meeting. None of us quite know how to do this. Oh, Representative Fettgetter.
Thank you, Mr. Chairman. I apologize in advance for going off topic just a little bit here, but 10 weeks ago, we began these meetings, and when we began these meetings, Mr. Chairman, we asked the industry specifically to come together and come up with language that they could agree on. And we asked them to put aside their issues. Because if I recall correctly, the very first meeting where we had different people who had brought forth the, the state question, they'd either campaigned for, collected signatures, worked on the language. They had many issues amongst themselves that they needed to work out in order for us to be able to work together. So, I was given, this is dated from July. I was given this on Thursday. I got this 6-7 weeks ago, which has legal language in it. This is like ideas. And I just don't know why we're not just why are we not just working with the group of the Unity Bill and working on off of this working draft. This was a working draft that the industry came together and gave to us. They put their differences aside and said, here's what we can live with. This was a working draft to me. It wasn't like we were going to go in and pass this tomorrow. I just don't understand why we're working off of this that I got in an email on Thursday when I've been reading this. In fact, it's been so confusing that Representative Rosecrans thought this thing was 500 pages the other day in an interview. He's read this thing so many times. I mean, this is where we've had all our focus. So I just believe that we should have been talking about this for weeks now. We should have been having meetings like this for weeks over this so that we could prepare. I mean, this is a lot of language that we need to still, as a committee, I believe, come up in agreement with. And we need to adopt this as our working draft going forward, in my opinion. And so I'm just asking, why are we working from this as opposed to this that we requested?
Apparently, Senator Daniels wants to answer that question.
Thank you. Well, I just want to say that I can agree and disagree with the gentleman on both counts. I believe ultimately we will be working from that draft, portions of which I may or may not be able to support. But I thought in terms of the passage of 788 and the very short time frame for implementation for the basic program was such that if we could get the labeling and testing skeletal regulations implemented, and if the Department of Health had that authority, then we could give them some comfort that it's moving while we consider this very comprehensive draft, which I too have been reading and studying. And what's happened for me over these last several weeks is the language in that Unity Bill, and I didn't participate in any discussion about asking anybody to go draft a bill, but I'll work from any draft that comes to me. But what I needed to do was understand the subject matter of that bill, and all these sessions have helped me. Yesterday, I attended one on financial services for marijuana. And that was a whole new eye-opener for me. So I'm learning as I go, and certainly we could have come in here and met every day for several weeks and be further along. But given the time of year and an election year and people's campaigns and the overwhelming comprehensive nature of what we as a state are trying to do, I think we're working fairly efficiently when you compare us to Arkansas, Maine, whose programs were voted on years before they were implemented. I'm confident that come regular session, we're going to be able to say to our colleagues, we have vetted this, and here is what we believe you should pass and be on down the road. So this isn't a stopgap. This is just to help us inch towards the final solution and get the program going. So sorry to be so long-winded, Mr. Chairman.
You're fine.
For a response.
Sure.
And I agree with you. The difference, and I think what I'm asking is, I was sent an email with this. I think I received it on Thursday. I've been reading through this over and over, trying to process it, meeting with the people who worked on this, trying to make sure I'm bringing all my municipalities in my district in to meet with OML so that my municipalities aren't getting sued. I am working my tail off on this issue when I should also be out probably campaigning. But with that being said, what matters to me is we did in the second week, I believe Co-Chairman Eccles in this meeting, I believe it was the second week, asked the industry to come together and put something that they could all agree on together. And this that we're talking about today is different than that language that we requested from the industry. So I just don't understand why we're working from here as opposed to here, and why we didn't several weeks ago, talk about adopting this language, which is what we passionately call the Unity Bill, adopting this as the committee's working draft to work towards a solution to all these issues going into session. So while I agree with you, it's been arduous and we've been working diligently, I just think that we requested this, and we should be, if you've read through it, I think it's reasonable. The rules on testing came from Colorado's. This big stack of papers is information that has been gathered from other states that are, this is kind of let's put the best case scenario together based on what the problems have been in other states. So that's all I'm asking is, why are we not working from, the set of rules out of the Unity Bill, and we're working from this? That's my question.
Okay, I'll make my stab at answering the questions, and it's going to say the same thing she did in large part, but we'll try again. One is, as you just said, the Unity Bill is regulations, and we are attempting to propose rules today. So that'd be one reason that you're working off this, and I do apologize. As you said, these have been out since July the 7th. If you did not read them until this week.
I'm aware of it. Yeah, I've read them. I'm just wondering why it was handed to me last week, and this is what we're moving forward with.
Because, again, the State Department of Health, I now have transcripts. So September 5th, the Department of Health was here and testified that they believe that they do have the legal authority to implement testing. It was our belief then, thank you very much, and when I say our, this is co-chair and I had discussions after that meeting. The express wishes that I understood from this committee, at least from the Senate members, and I believe his understanding from the House members. There have been press releases since then talking about how incredibly important testing is, and how if there's any one thing that we're going to fix, and this is something that we can fix now, since we don't get to decide if we're going into special session, we can do this. This is the most important thing that we need to do. So it's the number one priority and we can actually get it done. So we decided as a committee to actually work on those things that we can get done right now, not saying that once we get past this, once we kind of try to give that nudge to the State Department of Health, then I absolutely believe that it is the work of this group to put together some very comprehensive statutory language that we recommend back to the Senate and the House of Representatives, whether that's going to be in February, whether that's going to be in special session. Either way, yes, I think that is the goal of this committee, is the final result of this committee should be a comprehensive bill on how to make 788 work and how to make 788 work well. And I absolutely think that the Unity Bill is the jumping off point on that.
Thank you.
Okay. Representative Copeland, did you, I thought I saw your hand go up while I was speaking. Thank you.
Thank you, Mr. Chairman. One question I have is you make a distinction. Can you clarify to me what the difference is between regulations and rules?
Okay.
I'm not really sure that I understand that distinction.
Okay. So, and you're going to get me way out of my depth. You've got lawyers on both sides of you, so they may be more.
Well, I'm not a lawyer and you're not a lawyer. You just explain to me in common layman's terms what you think the difference between a regulation and a rule is.
I believe that the State Department of Health has limited authority to make rules. The authority that they have to make rules is granted to them through statute. So if we're making a statutory change, we as the legislature have the power, somewhat unlimited power. Obviously, we're reined in by the Constitution and many other things. But the State Department of Health does not have the same amount of power as the legislature does. The Department of Health, and the lawyers are looking at me like I misspoke. So y'all fix what I'm saying here when I get done. But, so one example, to give a concrete example. One of the things on my list for us to talk about today is laboratory standards. And that's one place where there is a big difference between the Unity Bill and the Department of Health. The Unity Bill calls for the State Department of Health to license laboratories. It is my understanding from talking to staff that through the rulemaking process, you most likely cannot create a new license out of thin air. That if we want to create a license regime, that would need to go through statute. But through rulemaking process, you can implement standards for laboratories. And so the State Department of Health uses, ISO IEC standard 17025. Which is also the standard that the national expert said that we should expect from our laboratories. So that would be in the rule language is standards for laboratories, but the rule language does not actually have a full licensing regime because rules can't create, they don't have the authority to create something like a license regime for laboratories. Does that answer your question?
Now let me repeat back to you what I think you just said.
Okay, please do.
And you see if we agree on this.
I think that's great.
Okay. What you said is the staff said they can create rules under their authority, but they do not have the authority to license anybody to do the testing. Is that correct?
They cannot create a license.
A licensing system for somebody to do the testing, correct?
Correct.
Okay. At what point in time will product be available to the consuming public in this state to buy medical marijuana?
I'm sorry, say that again.
At what point in time will someone who has a license be able to go to a dispensary and purchase product? in Oklahoma today.
Are you?
Yeah, Mr. Chairman, can I assist in that answer? So two questions, Mr. Leader. As to when can they do it, they can home grow now. So nothing has
I'm
changed.
not talking
but
about home grow. Don't bring up another issue. I'm not talking about home grow. I'm saying at what point, if I have received a license.
I still understand your question. I'm
Okay.
just waiting patiently for my turn to talk.
All right,
Are we ready?
I'm ready.
Okay. So what has happened is that question can only be answered with how long it takes a grower to grow and put it in the market. So what is happening right now is licenses were issued pursuant to 788, both grow licenses and dispensary licenses. What I'm assuming has happened, because nobody's asked my permission, but because there's already licenses on growing, is there seeds in the ground right now. What I have been telling people is that I anticipate, absent the legislature taking some action to stop it, there's nothing the legislature can do to speed it up. The only thing we can do is stop it. But assuming the legislature won't do that, in which, for those listening, I would not be in favor of that, and I would stop that. And I know the co-chairman wouldn't either. My guess is the end of November would be probably the earliest that I think, if somebody already had, if they were determined to, if they were to take down a grow before full maturity to be first to market, I would imagine something like that. If you didn't do that, if you waited till full maturity, you're probably looking at in December would be my guess. But I think the end of November, because my guess is there'll be people that will want to be first movers, so they'll take a grow down early. That's my guess.
Follow up.
Yes, please.
So we agree that, let's say December, let's say the 1st of December is the very first time that a person can take a license into a dispensary and purchase product. But you cannot license a testing. The State Department of Health cannot license any entity to test. They can set up rules. Even though Director Bates, my understanding when he was here, said they couldn't, but you say the staff says that they can, so let's agree. Let's say the staff says that they can set up the rules, but you can't test this product because there's nobody to test it. Is that correct? And I know at the last meeting, or meeting before last, when we talked about in-state entities that did testing for the state, the lady that was here from the legislative committee or whatever was supposed to get back with me about how the 2 states that were doing that, and she never did. So I assume if that was the case, you could have in-state testing done in the interim, but until you can license a testing entity, no testing will take place until we are in session, either special or regular session, to implement the ability for them to license someone to do the testing. Is that correct?
All right, and while you were talking, I was able to look down at and try to get, so, this again, where I'm not a lawyer, if you have the working draft version 1.5 from the State Department of Health, and this is one of the things that we talked about with the national expert, is actually one of the things that my co-chair pushed pretty hard on, because what you bring up is a huge issue, is that if we're going to implement testing, someone needs to be able to test it. And so that was one of the issues, and it's one of the things that we've worked on. But in draft version 1.5, there's a section, it's page 1, and I won't read the whole thing to you because it's legal language and it makes my brain hurt. But basically what it says is that if a laboratory is pursuing accreditation and with ISO, IEC standard 17025 and compliant with ANSI ASQ protocol, that a temporary, and it actually does use the word license, so maybe, again, this is where not having a lawyer at the front of the room hurts us. they can receive a 12-month provisional laboratory approval. And so in my reading of that and my understanding of the whole reason, and it ends up actually being you can operate a laboratory for 2 years, for 24 months, as long as your lab is seeking to meet the accreditation standards and operating underneath those standards, then you will be approved to test marijuana in the state of Oklahoma. And so if the State Department of Health were to approve these, from my reading of it, a laboratory could immediately go into, begin testing, assuming that they have the equipment needed to test marijuana, as long as they are moving towards these protocols. Does that make sense? Does that answer your question?
So what you're saying is they don't need a license for 2 years. They can test without a license from the State Department of Health. And if I remember correctly, didn't the national folks here that were talking about testing say it at best case scenario was 9 months to set up a testing facility, and it was generally about a year? I believe that was the case. A year was normal, but best case scenario was 9 months from the time that they even started setting up a testing procedure.
It is my memory, and obviously it is only my memory. So
well, mine is as well.
Is that it?
Mine too.
That was the time frame for certification. I mean, if there's a lab in Oklahoma that has the machines now, they could start that. They could start testing. And again, I may misremember here, but my memory was that it's a minimum of 9 months to get the 17025 certification. But part of getting that certification is that you're actually already testing products. Part of the certification is showing that you can test these things. So basically, these labs would be using the marijuana being grown in Oklahoma now to help them get their certification over a 9-month to 2-year period. But I don't think that this is a barrier. I think that if the department were to move forward with this quickly, I think we could actually have testing in place before the first harvest.
Well,
yes, sir.
But if they're not, I don't believe they would be, they couldn't actually put on a product that they have tested something that quickly, could they? I mean, because they're not licensed. They're in the process of getting it, a provisional implementation. So they couldn't just, I guess my concern here is that timeline. So at what point, let's say best case scenario that you have, at what point would this XYZ company that decided they're going to test, if they're already here testing or if they're going to come in and establish testing, at what point can they put a label on a product that a person goes into a dispensary and purchases and feel confident that that testing meets all the standards that's required by the Department of Health?
Senator Daniels, you want to try to answer this?
Yes, thank you, Mr. Chairman. So I'm reading through page 1 here. The only place the word license is used is under that provisional testing lab approval. Up above it says testing lab must be approved by the department. Laboratory approval says no testing until approval. So what I think we're doing here is something short of a full accreditation and licensing, because that is going to take legislatures, that's going to take legislative language. Again, we're trying to get this up and running, and I don't think we should be so hard on ourselves that we don't have a final product, but if we can get something going, they can do the testing. Yes, will the label say that they are a fully accredited, licensed Not necessarily, but for those who wish to be able to purchase and use medical marijuana as quickly as possible, this is our way of facilitating that, still with some standards, but not with the final decision, will the state be licensing them? Will they simply use national accreditation and those rules? We're trying to move expeditiously to get some testing done. So that's why I think whether or not they are fully licensed or have passed all accreditation standards, whichever ones we choose as a legislature to finally implement, they can begin testing and they can begin working towards the standards that will get them that final accreditation or license.
Mr. Chairman, for a point of information, the first product, which is the words that you use, the first products to be sold out of a dispensary was 2 days ago when there was a seedling plant that was purchased in a dispensary. So there's product, using your language, there's product that is currently being sold to the public, just for a point of information.
And real quick on that, though, so nobody freaks out listening, that was a plant that was sold.
Right.
Yeah,
No,
so and that was, yeah, for a product considering a non-plant, yes, consumable, yes.
Right. Senator Brooks.
And I apologize in advance because this is kind of a legal question, but is it constitutionally, is it the appropriate role of the legislature to send language to the health department for them to rubber stamp as regulations?
Either one.
Well, I think you have two questions in there, Senator. First off, you've been a lawyer longer than I have, so I'm going to be careful on this. But appropriateness and constitutionality, I think it's constitutional because anything we send to the department, they don't have to do. Right. So I mean, there's no requirement that anything that any committee, any recommendation this committee makes that the board would do. As far as appropriateness, I would actually, knowing you and me, probably not surprising, I would agree with you that it is something that should very rarely be done. I don't think this should become the norm by any stretch of the imagination, assuming we can come up with language that I can live with, and every committee's member is going to have to make that own decision that they can live with. I would vote to do it if it was the right language under this scenario, because I do think we are outside of the norm, and in order to appropriate the will of the people, if there is solid language that could be done faster, I would be in favor of it. But I don't see a constitutional issue unless you can show me one. I probably would agree to a continued practice issue would make me nervous, would be my response.
Follow up?
So are we going to vote on the recommendation today? Is that going to be part of this?
It is, no. My hope for this meeting, or our hope, I believe I can say for this meeting, is for the bill drafting staff to have a clear understanding of what this committee would like to see in proposed rules, that those proposed rules would then be written after this meeting, be presented to the committee in a final form, and at that point, we will be given the opportunity to vote on it. Today's goal is merely to set forth those priorities and give direction, kind of like I said at the beginning. I mean, typically, this is one senator or one representative going to staff and saying, here's what I would like this bill to look like. Again, going way outside of the norm, what we're doing today is trying to speak in one voice of, these are the things we would like to see in a bill draft, and ask staff to go make that happen. So, did you?
Yeah, I have nothing to add. I'll wait for the leader, and then I had a question.
Leader Copeland.
In light of what has just been said, is there an agreement between Mr. Bates, the staff at the Department of Health, that they will implement whatever this committee recommends to them to implement, or with the approval of the Attorney General. I assume he's going to have some role in this since he had a role in the prior. Is there an agreement with all parties that whatever recommendation this committee puts forward, they will adopt?
No. I think that it would be, and this goes somewhat back to the Senator Brooks question. To me, I do not think that it is appropriate for me to go and personally, one by one, lobby the Board of Health to tell them how to do their job. It is my hope that if we speak with one voice, that they will take that seriously and they will give that due consideration. But no, there is no guarantee at all that the Board of Health will adopt anything, and there is no guarantee that the Board of Health will adopt exactly what we send. I mean, we can send anything we want as a recommendation. The Board of Health has the power here. Yes, sir.
So anything short of a special session where legislate statutorily we send it to them, there's no guarantee that they would implement it.
Correct. Anything else on this subject? Representative Loring.
Thank you, Mr. Chair. So one of the concerns that I have with regards to the testing issue, and I agree with what I'm hearing is kind of the consensus that there needs to be some rules put in place for the testing. But my concern is, how does a testing facility handle a federally Schedule I drug without the license that they're not going to have?
Go ahead if you'd like to try that one.
Yeah, I mean, and Representative Loring, this question comes up all the time and is a very legitimate question about that it's still a federal Schedule I drug. The way we're going to handle it in Oklahoma is the same way 29 of the 30 other states that have medical marijuana handle it, in which is essentially we're going to ignore the feds. I mean, I know people are uncomfortable saying that, but the sooner we kind of just wrap our mind around it, the better, because we can't change federal law. This legislature is not going to change federal law. And the same way they handle that in the other states is and 29 of the 30 states that have testing, this is going to be a bigger issue, the Fed issue, when we deal with banking, because we can't just ignore the feds because they take away your FDIC license. So we're going to have to get as creative as we're capable of being. But your question, though, and I'm not being, I hope you understand that, I'm not being flippant. Like, I agree. I mean, I think it causes some issues, but I think the only way to handle, at least how I handle it in my mind, for me, and every member's got to do their own. I represent the citizens of the state of Oklahoma. The citizens of the state of Oklahoma voted for 788. So they told me it was my job to try to implement that when they voted for that. So to the extent the federal government still outlaws it, I mean, I'm going to do the same thing with the federal government. Has issued a memorandum that says if you have a medical marijuana card, they can seize your guns. I have every intention, and I bet I'll be joined by every member of this committee, to pass a bill next year that says law enforcement officers for the state of Oklahoma don't enforce that. If the feds want to come down and do it, then they can do what they got to do, but our law enforcement officers are not going to do that. And that's the only way I know, in my mind, how to handle it. But I'm not trying to make light of your question, because I think it's good.
Follow up.
Well, thank you. So let's not discuss sanctuary cities, but the other issue that I have here is, and I believe that every legislator that is sitting here has the utmost desire to try to implement 788 as it was enacted by the citizens. But as I understand the Attorney General's opinion with regards to the first rules that were issued by the Health Department, the gist of the opinion, in my understanding, is that there was not statutory authority for some of those rules. And that same problem exists with regards to some of the other issues that we've been addressing here. For instance, when the Chamber of Commerce was here, their concern on behalf of businesses was there's not the legislative guidance through statute as to how to deal with some of the issues that they're going to deal with. So the other side of that same coin is licenses are being issued to growers, to processors right now. And I think when the legislature finally does something to help clarify these issues, we're going to change some of the terms of those licenses. And those are going to lead to lawsuits against the state. And every day that we wait to give that legislative guidance, to enact the legislation that needs to be done so that we can adequately and fully implement 788, we are buying more lawsuits against the state. We are increasing the damages that are going to be assessed against the state. So while addressing these rule issues, yes, is important, but I think addressing the statutory issues is just as important. Wouldn't you agree?
Say that again, I'm sorry.
Wouldn't you agree?
I would agree, and I think you would agree with me that I do not have the power to call a special session. So I don't think that that conversation is really helpful in moving us forward to doing the things we can do today. Yes.
And I'm not disagreeing. We individually don't, but collectively we can call ourselves back into special session.
Okay. Other conversation on this before we get back to the original question on terpenes? Well, see how good I am at ruling with an iron fist and keeping us on subject? Yes, sir.
So I have, not as co-chair, but kind of a question / comment. We've said some things today, because I'm going to get us back on topic based upon some things we've said today, which gave me a lot more comfort. I heard several of the members of the committee today say for purposes of bill language, they think the unity bill is a good draft to work with, which I've said that on numerous occasions. I agree with that, and I'm happy with that. I'm glad to hear that. I don't have an issue. My overarching goal in these questions, Mr. Chairman and members of the committee, is whatever we send our ideas to the Department of Health, it is nothing that delays implementation of 788, so we know where my head is and the types of things I'm looking at. So in that regard, I do think adding in testing for terpenes is a good idea. I have some language that I have been working on with Dr. Lawrence Pasternak and Chris Moe on a conversation we had when we were working on some ideas that made it into a draft of the Unity bill. I'm happy to send to the committee. I think testing for terpenes is a good idea. I think we should have labeling. I also think the second issue that's come up as it relates to licensing by the Department of Health, I like that idea, but I would be willing to compromise and add, instead of having licensings by the Department of Health for testing facilities, have a requirement for ANSI certification if that requirement can be satisfied over a 2-year period, meaning a lab has 2 years to get that ANSI certification. Because the reason, Mr. Leader, I remember so well, what they said about ANSI certification is that was in what I'd like to affectionately call my cross-examination. When the experts said they liked the Department of Health rules, that's one of my major problems with the Department of Health rules is the way they stand. It requires ANSI certification of a lab according to their own website. That the average is 12 months. But I would say I would put out on that issue if we give labs 24 months, after 24 months, they need to have that ANSI certification. I would be willing to accept that as a compromise.
Okay, so to try to restate what my co-chair just said, his recommendation, which I would agree with, would be to take the regulation, the language from the Unity bill that deals with terpene and testing for terpenes, and to request staff to add that into a language request that we would make. We'll deal with that, and then we'll go to the laboratory testing part, but is taking that language out of the Unity bill and moving it into the regulatory language, or not, I'm sorry, the rule-making language. Is that the wish of this committee? Senator Daniels.
Really quick, I'm scrolling through the Unity bill here. Where is it in there? Where's the terpene part?
It's going to have to be in it. Thank you for that question, Senator. It's going to have to be some language that I'm going to send you. That's why they may not even make it. That language that I was working on with those gentlemen, I have found out did not make it to staff. So I do have that language. I'll send it over to you. Essentially, it is a change to Section 28M-2. In Section 28M-2, you have the section that talks about what is to be tested for. It has your traditional cannabinoids, CBD, CBDA, I'm sorry, THC, THCA, CBD, CBN, some stuff in there. Inside that section, it adds in and I don't want to say the wrong amount, but quite a few terpenes. And I'll have to send you that language because I did not get it to staff.
And I obviously can't find it right now, but it's my belief that Section 26 of the Unity bill actually is the section that calls for terpene testing itself. So I think it's going to be, and I may have that wrong too, but that's my notation is it's from Section 26. So it may be an amalgamation of many different sources. So back to the question of, is it the desire of the committee to add this terpene testing to the final product that we may look at next week, Representative Loring?
And I completely agree that should be in there. I just want to reemphasize, I think that we also ought to require that in the license, or in the labeling.
Right, oh, absolutely. And does anybody have any objection? I think that would like to just move forward with the assumption that any changing that we may make to the testing rules that the department had, that we're also going to make a corresponding change in the labeling section. And so the State Department of Health did not roll back the labeling rules. They have labeling rules in effect now, which was one of the big arguments that made it clear that we could do this testing part. And so I absolutely, testing for terpenes but not reporting the test results it'd just be stupid. So unless someone disagrees, any change we make needs to be a part of labeling. Any other thoughts on terpenes? No one has said no. So at this point, speak now or forever hold your peace, or at least until next week when we have actual language to look at. Okay, so David, we would like terpene language to look at next week. All right, on the actual laboratory, which is what we spent a lot of time talking about here, what my co-chair has said, and I know this is a huge bone of contention. I mean, this is a big change. And it's one of the things that the authors of the Unity bill, I feel pretty safe in saying the laboratory rollout being less than 24 months is a huge problem. And so I very much think that we have to fix that. Given, again, what my co-chair said, and I will agree with him, and given what the national experts said, that 17025 certification is the gold standard. I believe that we should, and it is already in the Department of Health's regulations. So we move forward with that, making sure that the language is very clear that laboratories will be given up to 24 months that they can operate under a provisional accreditation so that we can have testing up and going as soon as humanly possible in the state of Oklahoma. Is that agreeable to the committee? Have some head nods. I have one person that's really got heartburn right now. Go ahead. Yes, Leader Copeland.
This is probably a worst case scenario, but let's assume that half a dozen or 12 companies decide they're going to apply for testing. And in that 12-month period, at the end of or 24-month period, at the end of that they don't qualify. And so they have tested product for 24 months, but they don't qualify at the end of that 24 months. Am I being too harsh in my analysis here, or does that seem like a problem to anybody else?
Let me try to restate your question, make sure that make sure we're going down the same path. Your concern here is that if we go in this direction, you're going to have a lab operating, testing this product. People in Oklahoma are going to be buying their medicine, believing that label, the testing results on that label are correct. At the end of 24 months, so 2 years later, we could find out that these people really didn't know what they were doing. And that's the concern you're bringing up. Is that correct? Yeah, I absolutely agree with that concern. Representative Warren, did you have?
Well, I would just respond by saying I understand that concern also, but still having some testing done is going to be better than our current status of having no testing done. So it's better than where we are right now.
And let me equate it to the world that I actually know something about, so the hospice care world. So I started 2 different hospice companies through my career. The process for that, which is very, very similar to this, is when I wanted to start a hospice company, and it's still the process today. If I wanted to start a hospice company today, I go to the state of Oklahoma and I request a license, and the state of Oklahoma comes to my office and looks at my ability to provide hospice care. It doesn't look at whether or not I'm actually any good at it, but it looks at all the proof that I can give to show that I am ready to provide the care that is required to be provided. If I pass that, which is mainly looking at policy and procedure manuals and looking at certification levels for my employees, when all of that is done, the state of Oklahoma gives me a license. But that license is not a Medicare certification. It is a license to operate as a hospice, but not to get paid as a hospice. What happens next is I'm required to take 10 patients and take care of 10 hospice patients. I mean, you don't want to mess that up. You only get one run through hospice normally. And so there are 10 people in Ada, Oklahoma, and there are 10 people in Norman, Oklahoma that truly were guinea pigs for my company. And until I had done that care for those 10 people, Medicare wouldn't talk to me because they wanted me to prove that I knew what I was doing. And it's the same process for these laboratories, that you can say, I want to be 17025, but until you actually get some weed and test the weed, They don't know for sure. And so it's a 2-year process. In hospice, it's more of a 6-month process. But the first people that we take care of with no guarantee that we have a clue of what we're doing. And we provide that care. And it's the same thing here, but I'm going to agree with Representative Loring, it's better than nothing. Yeah, and I know you don't disagree with that, but I don't know how to avoid this problem.
Am I jumping ahead to make another recommendation, Mr. Chairman?
You are. Let's finish this.
Okay.
Are we good going down this path? Clearly telling the State Department of Health that we would like rules that include 17025 standards, and that we really want to make sure that they have 2 years between when they can start testing products and when they have to have actually completely achieved that certification. Is that the direction we want to go here? Your silence is assent. David, please do that. And I don't think that there are any huge changes in that section, but it is a big difference between the Unity bill and the rules. So, all right. Yes, sir.
So, thank you, Mr. Chairman. So as we go down this road, another concern I have, again, I'm trying to hit the big concerns before we get into the specifics, is it's going to take about 6 months for these labs to get set up. So a suggestion that I would make is that whatever testing requirements we come up with, that they are not effective for 6 months from the date of their effective date, which, yes, I know means there will be 6 months where there will be non-tested product on the market, but I don't know of another way to do it unless we're going to just delay 788 for 6 months.
All right, I would like to admit that I was talking to David and not listening.
That's okay.
Could you please repeat that?
So I'd like part of our recommendations to be that there be a delay for 6 months till the testing requirements come into effect.
Mr. Chair, I'd like to add a lot of us don't listen when he's talking.
Absolutely. But I listened when you came out for sanctuary cities.
All right, so to restate, your recommendation would be 6 months from the date that the Department of Health accepts these new rules, that there would be no required testing of products. Am I stating that correctly?
You are, and the reasoning behind that is it's going to take these labs some time to get up and running. So, I mean, I think doing anything else is, unless somebody has another idea of a better way to do it, I think anything absent that is just calling for a 6-month delay. Because they don't exist at this second, you know, right now, they're not up and running. Okay. So there's going to have to be a lag time.
Senator Daniels.
Thank you, Mr. Chairman. I can live with that, but we are entering a classic buyer beware. In order to get product on the market for patients, we're willing to say to the patients, if this is that important to you, that this be implemented as quickly as possible, you have some responsibility here to understand that instead of delaying it all 6 months, and I'm happy to support that because we're trying to get a fledgling industry up and running.
Yep.
Representative Copeland.
Thank you, Mr. Chairman. Back on this testing issue, I've been informed by an individual involved with it that there's, and when the lady from NCSL came and said that 2 other states had used state-owned facilities to do some testing, that there's one entity in the state that could do that, state-owned. I'm not aware of that. But if that's the case, would it be possible to let them do the testing in that 24-month period prior to the others getting established?
It is my understanding of the accreditation process that part of getting that accreditation is that you are doing testing, that they're going to watch you actually do the work and make sure you're doing it correctly. So I don't think we can have private laboratories start and get that accreditation without this phase in. So I don't think, if I understood what you said correctly, basically my understanding of what you said was, for the first 24 months, let's use a state-owned laboratory, and then after that, others can do it. I don't think that solves the problem, because they're still not going to be certified laboratories because they haven't been testing marijuana. Senator Paxton?
Thank you, Mr. Chairman. To echo what Senator Daniels said, I'm not real comfortable with that, but I could live with that. But maybe in the same process, if we are going to delay testing for 6 months, part of the labeling process is a big warning sign that says this product has not been tested, because in the patient protection concept, they need to know this has not been tested.
And I was on the same line of thinking as Senator Paxton. I'm very squeamish about allowing, the 6 months, but I understand that it may be necessary. But yes, I think if someone is going to take this medication that has been completely untested, no clue what heavy metals may be in there, E. coli. I think there needs to be a warning label on it that says that this is untested and could contain harmful chemicals, or I don't know the wording.
Well, and to that, if I respond, Senator Paxton, compromise goes both ways. And if you're willing to compromise on that idea, I absolutely would agree to some type of warning label like that. I understand. I need to meet you halfway too. That seems, and Senator Daniels, that to me would not bother me, because it would have the ability for it to go forward. And then I agree with Senator Daniels and yourself. It is a buyer beware market. It's not my first choice. It's telling when the entire industry and everyone is saying we need to do this, some form of testing requirement. We're just kind of dealing with it. There's going to be a lot of speed bumps along the way, a whole bunch. But if we can pull this off as quickly as we've pulled this off and set up a good functioning market, we really would be the standard for how to do this. And I think what you're talking about helps us get to that. It's that transition period into testing. So you'd have my 100% support on that.
All right. Other thoughts on having a 6-month period post passage of these rules where product is not required to be tested? I do want, and I want to make this clear and make sure that we're all on the same page, that if there's a lab that's opened up, voluntary testing can be done during that time period. So it would become the choice of the grower on whether or not they want to have their materials tested during this 6-month period. Is that, and any untested material would have a warning label making sure that the person purchasing that would know that it has not been tested. Senator Yak.
Thank you, Mr. Chairman. By the way, this is not going to be a 20-minute meeting, so I think we determined that early on, right after your terpene question. So where are the nearest? I have some real heartburn with putting out a medication out there that's not been tested. And I'm for that if the compromise is putting a big warning label on there, then I guess I can support that. Where are the nearest accredited labs, understanding there aren't any in Oklahoma? Where would those labs be that exist today?
I do not know the answer to that, but the problem I see with where I think you're going with your thought process is that I think you're about to suggest that we transport marijuana across state lines, which the federal government would have an issue with. Follow up.
We agreed a long time ago that we're thumbing our noses at the federal government at this point. So I don't know where that ends.
Yeah, please.
Thank you. So Under this scenario, is there anything to keep a grower from, I mean, if I'm going to buy this medication, is there anything to keep a grower from having his product tested by an out-of-state laboratory that may make his product more attractive to me as a consumer?
I don't know. I mean, I would think the answer is no. It's entirely possible that if their lab's one state over, that, I mean, they may have some regulations, you know, that state, they may not want to accept it. I have no idea. I mean, obviously I can't speak for an out-of-state lab company, but it would seem to me that if you wanted to take your marijuana across state lines and get it tested and bring it back, I don't know that we would stop you from that in any way.
So I do have an idea to that end, though. When you were talking about, and I've gotten some texts about some people that say they're going to do their own testing, we could easily set up, Senator, a voluntary testing. So one of the ways to avoid during the 6-month window where there's not mandatory testing, if you do test your product and label what's in it, you don't have to have that "this is an untested product" label. So we have an incentive. So instead of, we use the carrot, not the stick. We incentivize testing during that 6 months. I don't know exactly what that would look like and how we would do it, but I think that might be a good idea. I am nervous, and I do agree we're thumbing our nose at the federal government, but I don't want to go from thumbing our nose to slapping them in the face, and I think transporting it across state lines could, to my knowledge, we'd be the only state that is that brazen, and that would worry me a little bit for those transporting it, I guess is all I'm saying.
And I'm not saying that I endorse that, but if I'm a dispensary and I have a product out there that there is an adverse effect from, we talked about lawsuits earlier, they're really on the hook for that. So if they can mitigate those by doing their due diligence in some sort of testing, in my opinion, that's just the prudent, it's their own operation, but in my opinion, that's the prudent way for them to operate. So I don't know if that's, I guess that's just a comment, Mr. Chairman, so I don't know how we can, I'm not saying that we endorse moving product across state lines, but if we don't prohibit that, then I think that would be a good thing. Thank you.
Senator Paxton.
Kind of on the same line, Mr. Chairman, if we're going to do this and have this 6-month delay, but you still can test, and as that from a marketing standpoint, if I owned a store that's selling this and my product was tested and my opposition was not, I think it's a great marketing deal that this product's safe. So I think the free market's going to speed this up a lot. Someone's going to jump in there with a mobile testing lab or some type of a deal to come in there and get this product tested. In the same deal, if they're not going to use that big bold print that says this product not labeled because they have tested it somehow, I think that's part of our recommendation to the State Department of Health is to come up with the rules as when they would not have to put that big label on there. Like when you look at their rules from the July 7th, it says the lab may request provisional license approval prior to accreditation provided it meets all other requirements. If they're meeting their language from the July 7th rules, then they can do without that big bold label that says not tested. Because I think that's going to speed the whole process. I think the free market will push that process way in advance because that would be a much more desirable product to purchase, one that has been tested, and they can do that. But there just needs to be some rules of when you do not have to put that big label in that first 6-month provisional time frame.
I agree. Representative Loring.
I understand where we're going with this, but my concern is then a grower could test for something that is totally irrelevant to any consumer and then be able to say on their label that it is tested, which in no way protects anybody. And so I have real concerns about us trying to carve this exemption out of there.
So does that mean that you're opposed to the 6-month waiver? Or
No, I'm in agreement basically that we need to have a 6 months waiver. I agree with labeling something as not being tested, but I have a problem with coming back in and letting a producer, a grower, whoever, a dispensary, say it was tested when we really don't know what it's been tested for.
I understand that.
Just to say it's been tested.
So is there a way to specify if it is tested in a provisionally approved lab by the State Department of Health, at that point the sticker comes off and the testing is deemed acceptable? But yeah, you're right. I mean, if I just tested at home, that's probably not the standard we're looking for. Senator Paxton.
Thank you, Chairman. I think that's what I was trying to get at with my prior statement was, in order to get that label not put on there, the not tested label not put on there, it does have to go through an accredited, or not accredited, but an approved lab that's testing the way. In other words, they have to go through the State Department of Health in order to be able to take that label off of there. The State Department of Health, through their rules, can have all those regulations in there that they need to make sure they're not just testing for dust or something. They're testing for actual, the things that they would be testing for in the regular market.
It seems that everyone is in favor of a 6-month waiver with the assumption that any untested product is marked thusly, and that as labs do come online, products that are tested in that 6-month period can have the normal label that would come with a tested product and will not have to have the big warning label. Is that, are we in agreement that that is part of the language that we would like to see drafted? We have shaking heads. Okay. You've been on a roll. You got any more?
Well, yes. I would like on the, we had brought this up, so I guess we can go straight to it, and you've already brought it up, the heavy metal section inside the Department of Health regs, I think was too expansive. And so members know that the heavy metal testing is very, very expensive. That's probably the most expensive part of the testing. And my concern here about being too expansive is that it will jack up the price on the consumer. Now, obviously, heavy metals that are inside the soil in Oklahoma, I think, are very appropriate to test for. I mean, if we think we have a problem with that. So I would like to move, I would like to greatly limit the number of heavy metals that we test for as compared to the Department of Health, only to those that are necessary. And you may have known something. I think I listed 5, I want to say, but I could get the number wrong. So that would be my suggestion to the committee. Again, understanding it's very important to test for heavy metals that are present in Oklahoma soil to make sure they're not in there in a manner that's harmful, but we don't need a test for uranium. That's not an issue here, well, where it is in, say, California.
Let me say a couple of things before I call on you, if that's okay, just to give, and this is information that my co-chair also doesn't have. This is a subject that David and I have been working on this week. We have reached out to, and this is just for your information, we've reached out to DEQ, and we've also reached out to the Department of Agriculture to ask them the question, because one of the things that the national expert said is, your heavy metal testing is a state-specific issue, which is why, and I learned a bit from him on this, and why California is so over the top, other than the fact that it's California, is that the mining industry in California, the great gold rush, because of some of the things done through the mining industry in California, they have had heavy metal issues that are much greater than most any state. So I absolutely agree. Taking California's heavy metal testing model makes absolutely no sense. So we've been working to identify through DEQ and the Department of Agriculture what those things are for the state of Oklahoma. We do not have that final answer yet. The honest answer is they sent us a whole lot of information, and neither of us are scientists, so we're having to go back and try to get it in plain English. But the first blush answer from DEQ, so in the July 7th working draft from the Department of Health, they actually narrowed it down to 4 heavy metals: cadmium, lead, arsenic, mercury. And the first kind of top line response from DEQ was those 4 are really good. So we'll continue to work with DEQ and the Department of Ag over the next week to try to make sure there are not other things we need to be testing for. I think the answer we're going to get is that this is a really hard thing for the state of Oklahoma because different parts of our state are so diverse. And so parts of the state that have had mining have their own issue. Parts that have had massive oil and gas, they have a different set of issues. And so we're trying to figure out the answer to that. So I would ask for a little bit of latitude as we dig into that this week, that we may bring you back some more information that we may need to work through again as we continue to finalize language. So with that, I absolutely, cadmium, lead, arsenic, mercury, narrowing it down to those 4, I believe to be a good starting point. And it is, again, what the Department of Health actually finally narrowed it down to, I think with input from the industry. So with that, I'm sorry, Representative Copeland, that was a lot longer than I intended it to be.
Yeah, I forgot my question. No, I didn't forget, I'm sorry. So what we're talking about is heavy metals that are in the soil translocated into the plant.
Yes.
So my question would be, the indoor facilities probably wouldn't have, indoor growers probably wouldn't have that issue. And if a grower was raising a crop, couldn't they test the soil prior to planting and alleviate the need for a test of the plant? If you had qualified soils at the beginning of the plant, you wouldn't have to worry about relocation of the heavy metals into the plant. So a single test of the soil would eliminate the need for the test at the lab. But does that make any sense to anybody, or is it just the farmer in me coming out?
Right, I'm trying to get the farmer and Senator Paxton to come out and help me here. It is my understanding that, I mean, yes, this is heavy metals being picked up from the soil. It can also be picked up through the types of fertilizer that you use. When you get past that, I'm going to be way out of my skill set in trying to answer questions. Mr. Co-Chair.
Yeah, and on that, Leader Copeland, you've forgotten more about farming than I know. So you actually would be the guy I would ask that question on to of the soil. So I'd like to run down that area. I don't fully understand. I'm being transparent. I don't understand it the way you do. I do know. I was looking at the food that there was a recommendation by the food safety standards for what their heavy metal testing should be for edibles, and it did include the 4 you talked about: lead, arsenic, cadmium. I got nothing. Cadmium.
I think it's Cadbury eggs.
Yeah, and mercury. Again, I think that was good. That was with everybody. I don't know if testing the soil would get rid of that requirement. If it does, and if that's a safe and a cheaper way to do it, then I'm for it. I don't know enough to know that. But I wanted to point out too, on this, they did limit it those 4. Worth looking at.
And I mean, one of the questions that I have for the committee would be, would you like for us to see if someone from the Department of Ag could be here next week to try to answer that question a whole lot better than, I mean, I at least live in rural Oklahoma, so I guess I'm the country boy of the 2 of us, but there's not a whole lot of country in this boy, so.
Mr. Chairman, I would think that you wouldn't necessarily have to have them come. You can talk to DEQ or the Department of Ag and just get their opinion of that.
Okay.
Or the testing entities that do this. I mean, there are other ways that those heavy metals, I know mercury is one thing. Coal plants, when they produce electricity, their scrubbers are supposed to take mercury out. And I'm not a, you know.
Right.
But I mean, you talk about fertilizers. I'm not aware of any fertilizers that contained a lot of heavy metals that would be used in agriculture or anything, so.
According to David, that's something that the Department of Ag brought up in our communications this week, is that fertilizer could also be a source. I know nothing, and water. So I guess if you've got metals in your water that you're watering, or I mean, if it's hydroponic, then Senator Paxton?
Thank you, Mr. Chairman. I just kind of listened to that question. I think there's some validity to, it starts with the soil, but when they put a loaf of bread on the store supermarket shelf, they don't rely on the soil test from the farmer through all those processes because there's so many other areas that could be contaminated. So I mean, I think it's a great start. I think we ought to look at that, and I think we're heading down the right path of asking the Department of Ag if that could be done, because I think that would be much cheaper. But I do think the reason they test actual food products further down the line is because there's so many other areas that it could be contaminated. So, but I love the process that we're talking about here, is that, what's the way to make it the most efficient and cost efficient to get it done. But I think we look at it, let the Department of Ag continue to look at that.
Any other thoughts on heavy metals? Senator Yek.
Thank you, Mr. Chairman. So I really don't know. These grow houses are not necessarily going to use local soil, I assume. I don't know what they use in these grow houses, if that's a particular mixture that comes from somewhere else. I assume it probably is, but we talk about being state specific. Is that really relevant to the question? I don't anticipate there being fields of this product. I look for most of it to be produced within grow houses. If there's a question in there somewhere, but
State Question 788 allows outdoor grow. So there is the possibility that people are going to be old school farming marijuana here in the state of Oklahoma.
I anticipate the outdoor grow being more of, maybe I'm wrong here, but being more of for my own personal use. I may grow it outside. I don't know if that's the case or not. Just another point, we talked about the cost of the product. I agree that is a concern, but I think our primary responsibility is a safe product. So if that means prudent testing, I'm for that, even though it will raise the price. I get that, and I don't know that anybody would disagree with that, but I don't know that cost is our primary concern here. Thank you.
Senator Daniels.
Thank you. We're making excellent progress, but this isn't a final product in that some of the points being brought up could make their way into a final legislative package or a final set of rules. 788 is statutory. I think over a number of years, as we grow in our knowledge of this industry, that changes will be made. So I know that David over there is making a note of every single thing we say, but not necessarily everything needs to go into these initial rules.
Thank you. Yes. So do we want to direct, I will steal the language from Senator Yek, that David continue to work this week, work with DEQ, Department of Ag, and come up with the most prudent but also cost-effective testing regime for heavy metals that we can come up with. Everybody okay with that? I have head nods. Representative Eccles.
So I've got another one. Anybody else has ideas, they can throw them out there, but if not, I got a list. So I'll try to email them out. So my next thought would be for a recommendation I want to throw out to the committee. You have what should be tested, and then you have the levels of appropriateness in the testing. What I will throw out, which I think is going to be the most controversial thing I've thrown out, in the original Department of Health regs, and I don't have those pulled up, they had very, very stringent amounts of propane, pentanine, things like that could be in there. Actually, the most stringent regulations in the country, except for California. In the food safety standards for processors, which was that was created by 788, had people from DEQ, Department of Health, had industry, had kind of everybody, in their proposed regulations, they went to what I'm going to call more of the Colorado standards for what should be in there. If you have those proposed regulations, they're on page 3. And this is also the most recent compilation work. These were the standards that were in the Unity bill. These happen to be the same numbers, but I'm not actually putting them forth as the Unity bill as my backup. I'm putting them forth as my backup, that this was what the food safety standards for processors came up with. And I would suggest that we use those standards when the Department of Health issues their regulations for what the testing amounts should be. And again, I would describe them as more Colorado-type standards than, say, California-type standards.
Could you tell me the levels on the 4 that cadmium, lead, arsenic, mercury, do you have those?
I'm glad you asked. Yeah, so lead would be less than 1 ppm, arsenic less than 0.4 ppm, cadmium less than 0.44 ppm, mercury less than 0.2 ppm. But I'm not just suggesting it for the heavy metals, I'm also suggesting it for the solvents in addition to that, the acetone, the benzene, the butanes, the hexane, the isopropyl alcohol, pentane, propane, toluene, total xylenes. I'm sure I have plenty of chemists or farmers. There's somebody in the room that if I butchered those, I pronounced them phonetically. So, but that would be my issue here is one of cost. We want strict testing, but at the same time, you can make testing so strict that cost becomes a major factor to the consumer. And these are working in other mature markets, and that would be my proposal. And they were what the experts, meaning both the health department experts, the OB&D experts, everybody on that food safety standards for processors board came up with. So we're not reinventing the wheel. This is what has already been proposed to them.
I'll ask the question of, if what you're proposing is what the people who drafted the Unity bill wants, and it is what the Department of Health most recently said they wanted, why did you start this with saying this is the most controversial thing you're going to say today? Yeah, unless you're just going to be really easy to get along with the rest of the day. Yeah. I feel like I'm missing something that I should be getting upset about right now.
I know, because I don't want anybody, I don't want to lay behind the log. So this is different, and this is, if you look at the Department of Health regulations, now I'm arguing against myself, but I do not want to lay behind the log. The Department of Health regulations, what date were these? So the July version of the Department of Health regulations had more stringent numbers than what I just read out. Now, the food safety standards for processors, that was a subcommittee inside the Department of Health, so it wasn't the Department of Health board itself. However, what I would argue, and why it may not be that controversial, it's what's in the Unity bill, and it's what that subcommittee, which was made up of Department of Health staff. But yeah, I'm going to be really agreeable today. That should let you know this is what I saw as my most controversial issue. I just didn't want to lay behind the log, and because I am making a change from what's in here, but I still think it's safe. So,
Senator Daniels.
I agree.
Others. We have consent from Senator Daniels. We have blank looks from everyone else that I will take as consent unless you speak now or hold your peace for 1 week. All right, then we will pass on to staff that we would like the testing levels, both for heavy metals and for whatever that other long list is titled, to match the Unity bill and the food safety testing standard rules that have been put out but not yet passed by the board. All right. Senator Yak.
Thank you, Mr. Chairman. I just want to make sure I'm clear. So these are levels that OBN has signed off on. Am I clear on that? I just want to verify that.
Yeah, and I'm glad. That's why my understanding, and this is my understanding, I was not in any of these meetings, my understanding is that they were involved. I'll double check in that, and if they were not, I mean, I'll come back and tell this committee that. So, but my understanding is that they had representation on the Food Safety Standards Board.
Follow up.
Thank you. Okay, so before I agree to that, I just want to make sure that that is the case, that they are agreeable to whatever changes we're talking about here. Thank you, Chairman.
That's a fair request, and I'll double check, Senator.
We can absolutely do that homework before we bring final language. Others on, Senator Daniels.
Are we moving on to the next topic?
Yes, we're moving on. I
Okay,
almost said on the subject.
So while we're dealing with lists, we talk about terpenes, but we see that, and I read a lot about testing these different things last night. I know just enough to be dangerous. What about water activity, foreign materials, sterility, and other, which were included in the Department of Health rules? Are we going to go and talk about any of those today? You spoke specifically about heavy metals.
We can talk about anything that the committee would like to talk about today.
So is there
yes, if you want to talk about water activity levels, it is my belief that the Unity Bill and the original Health Department regs mirror each other on the water activity. I may be wrong on that.
Well, it's not on this that they mirror each other.
David is telling me I'm wrong.
But it'll be the only time today, Mr. Chairman.
No, it won't be the only time in the next 10 minutes. Okay, so yes, apparently, from my cheat sheet here, you are correct.
So my question,
State
given
Department of Health regs include water activity / moisture content, foreign materials, sterility, and other, a category of others that are not included in the Unity Bill.
So my question, given what Representative Eccles talked about using a Colorado standard as something less restrictive, not having enough knowledge to weigh in on all of these, do we sort of leave that for next week and get somebody to weigh in on whether or not all of those are truly advisable? Or does somebody want to weigh in on them now? Because again, you can test for a multitude of things, you can measure a multitude of things, but being able to measure and test for a multitude of things does not necessarily make them dangerous or toxic or unhealthy. So I just don't want us to, again, overburden the industry, but there was quite a bit of discrepancy here between the Unity Bill testing categories and those in the Department of Health draft regs.
My suggestion would be, so I've done just enough reading on water activity to be dangerous, but from everything that I've read, it's pretty dang important. So, yeah, for multiple reasons, and basically if you have, to my understanding, if your water content's too high, basically a whole different set of testing you're going to need to be doing on that as opposed to a properly dried product. And so my suggestion would be that we continue forward with the water activity, foreign materials, sterility that the Department of Health has, understanding that I'm sure if that's a big problem, we will be informed of that before we show up here next week. Is that acceptable to you? Is that acceptable to other members of the committee?
Seems appropriate to me.
Okay. Other subject. The only other subject that I had on my list going into the day that my co-chair has not already covered is the amount to be tested, what a testing batch is. I believe that was an issue between the Unity Bill and the Department of Health. The Department of Health, and I will summarize this at about an 8 million foot level, but the Department of Health requires every 10 pounds to be tested. The Unity Bill gives quite a few ways that you can be exempted from that level of testing. One of the things I know when the expert came to testify, he's a lab owner, and when he was testifying, when he said this, I kept that in the back of my mind, and I want to put it out there now. He's a guy who does lab testing for a living. He was opposed to kind of being able to clep out of further testing for the sheer fact that once you do that, once you allow kind of the big farms not to have to test as often as the little farms, or on the same scale as the little farms, maybe a better way to say it, your labs start to go out of business. So I think we keep that in mind if we want to roll back the health department's regs. But it is a place where the Unity Bill and the Department of Health, the Department of Health did not make any exemptions for, if you pass X number of tests, then you don't have to test again for a certain amount of time. That does not exist. With the Department of Health, for every 10 pounds you want to put on the market, we're going to do some testing on those 10 pounds. Do any of you have recommendations or thoughts on that subject? Because it is an area of disagreement.
Could I ask a question on that, just so I understand? And this may be for you, Mr. Chairman, or for staff. Is the area of disagreement, both regulations said you test, I like clep out, so I'm going to use that for lack of, just because we got to come up with some vernacular to use so we know what we're talking about. Is the only area of disagreement both say test every 10 pounds, but the Unity bill says you can clep out of it for certain reasons? Or is there some other unit of testing that it uses other than the 10 pounds? Is my question making sense?
It does make sense. I do not know the answer to that.
It gives different, this thing gives different amounts based on how much the harvest batch is. But this says that every 10 pounds has to be tested, like you said.
All right, if I understand what David was just telling me is that, yeah, that it's the ability to possibly not test every 10 pounds is the difference. I don't know that for sure. There are probably people in the room that do know that for sure, but it's my understanding that that's the biggest issue here.
And for a quick follow-up, Mr. Chairman, and to be clear and make sure I'm correct, what we're talking about is testing 1 ounce for every 10 pounds, right? Okay. And they both have the 1 ounce for every 10 pounds, just one has certain situations where you could have less testing. Okay, I'll yield for some more questions, or I'll back up.
Right, and I know it gets a little more complex when, it gets into blending batches, and if you don't have 10 pounds, and, but yes, I think the 10-pound threshold is the key. Senator Daniels.
So again, ultimately, we might want to consider somebody who's up and running and been established for maybe some sort of exemption. But we're still talking about a fairly temporary set of rules to get us started. So I don't believe there should be any opt-out provisions this early in the game under these documents that we're working under now.
Okay. Other thoughts on this subject? I do with Senator Daniels. I think this may very well be an area where the rules that we recommend to the Department of Health and the final draft of legislative language may be very different. I think that makes sense in this area for sure. Representative Copeland.
Thank you, Mr. Chairman. Are we talking about every bit of the product produced by an individual taken to a lab and them going through it and getting the parts for sampling, or is it just a portion of whatever is the producer taking it, or is it being collected by another individual, an unbiased third-party person?
It is, again, from my limited understanding, I believe, and I'm totally going off of memory here, it appears from the regulations that I read that the lab or some laboratory personnel is in charge of choosing which part of this 10-pound batch gets tested. So if your question was, if I grow 10 pounds, do I keep all but 1 ounce at my place and I take 1 ounce to the lab? I do not think that's how it works unless the lab were to be coming to your place to choose which 1 ounce it is. I don't know exactly how that works, but both sets have regulation on who it is that gets to decide which parts of each batch are tested.
But the total amount of product has to be delivered to the lab for them to choose what they test in that batch or unit or...
That is quite possibly true. I think that's correct, but when reading the regs, and this is one of the questions that I had in the back of my mind, it seems to allow that a lab may actually send personnel to gather the samples, that would at least be an option. I really don't know the answer. So the recommendation has been to keep the 10-pound limit that the Department of Health originally had, at least for this episode of rulemaking, with the ability to maybe make statute with a little more finesse at a later date. Is that an acceptable direction for staff?
And Mr. Chairman? On that issue?
Yes.
I just want to reserve the right to learn more about this issue and complain later if I want to.
And I think, judging by the look on everyone's face right now, I think everyone is reserving that right. That this is something that, and that's something that we are going to need to talk about it as we move forward, is how we get some of these answers. It's really awkward for me right now to know that there are people in this room that absolutely know the answers to this question. We did not draft an agenda in a way that allows us to get those answers. So we need to figure out how to get those answers before we vote on final language. I would very much like for us to make sure that we've all been able to get our questions answered. It just really wasn't today's agenda, but we'll work on it for sure. Are we good with that recommendation? Every 10 pounds? All right. That is the last thing I had on my list. Are there other areas of testing that we want to, Senator Yeck?
Mr. Chairman, I might recommend this is a perfect time for a break.
With that, we will take a 5-minute break. All right, if members would take their seats. I think that we are pretty well done here. Unless there are other issues, I've checked everything off of my list of things that I knew that I wanted us to cover. Are there any other things on any of your lists of things that need to be covered before we ask staff to create this draft of the rules? Seeing none, I will go through what I believe we decided here to make sure that David and I have the same list, but it is, we would like to, working off of the Department of Health version 1.5 from July 7th, we would like to add testing and labeling for terpene. We would like to add some clarification to what I think it already gives a 24-month timeline, but it's pretty vague. We would love for that language to be made more clear. that we're going to use the 17025 standards, but we want a 24-month timeline for a lab to get its certification. We would like a 6-month waiver on testing, so for 6 months after adoption of the rules. Product can be sold in the state of Oklahoma that is not tested. If a product has not been tested, then it will be labeled as such, and we'll need to create the language for exactly what that label says. If it is tested by an approved lab, not just tested, but tested by an approved lab, then that warning label does not have to be used. We want prudent testing on heavy metals, and we'll do a lot of homework to figure out exactly what that is, and that's something that we're going to have to probably have a little more education on next week. And then we would like for this initial set of rules to test every every batch has to be no larger than 10 pounds, and that there is no exemption from that 10-pound limit currently. So those are the things that we have all agreed on in a bipartisan, bicameral way, and people said it couldn't be done. I guess we still have to actually agree on the language, so maybe I'm getting excited too soon. I appreciate the members of the committee. This was not pretty. We knew it would not be, and I think we all understand why some of this is done behind closed doors. But I appreciate your input. I appreciate you being here, being engaged, and I very much believe that today is a huge step forward in having a safe medical marijuana industry in the state of Oklahoma, and I appreciate all the work that you guys have put into making that happen. With that, Co-Chair, do you have anything to add?
I just want to add publicly, I was super nervous about today's meeting and how it was going to go, and I thought you did an excellent job. That's it.
Well, thank you very much. So next week we will start the meeting dealing with tax and banking issues to finish up that the part where we're learning. That should not take the full meeting. So after that, we will, I believe, although I've not discussed this with my co-chair, probably have some time to look at wording that has been created off of what we did today. Representative Fettgetter, you had something to add?
Yes, I just would like to request that we try to make sure that the next meeting and the meetings going forward, we all have the same documents that we're looking at, so that, because I was lost at different times, and then Senator Paxton and I realized why. So if we could try to make sure we get those documents out, it'd be great. Even if it's the morning of, it's great.
All right, sounds great. We will work on making sure everyone is working off of the same documents. That can be hard sometimes with what we're doing, but we'll try to do better for sure. With that, we will adjourn. Thank you, guys.